Delivery of judgment. Delivery of judgment. Item 1, WPC 5229/2016.
The review is allowed by remanding the matter. The date of appearance is fixed on 22/12/2025.
Right, please, Lordship. I would like to mention the listing of a case, Lordship, IA for suspension of sentence. The matter last came on 22/10 with a further direction that
Give it-
list the
give it to
case
the
after a
court,
week, Lordship.
Give it to the court master.
Day before
Give it to the court master.
Court master. Lordship, court master. May I please, before Lordships, I paid for listing a interlocutory application, which was last listed.
Prayer for listing, give it to the court master.
March.
Daily list item 1 for motion.
Statutory revision application. In fact, my lord, in respect of my lord, common judgment, which is assailed in the present revision petition, petitioner earlier approached this honorable court, my lord, and matters are pending before this honorable court. This matter may be tagged together, my lord, along with my lord, a revision petition 1 of 2024. In respect of other assessment here, my lord, judgment is common, my lord. Issue is, my lord, whether the assessing authority can levy tax, my lord, on the VAT element of
One over here.
1 of 25.
You're not challenging an order of 30/5/2024
2024, it was filed,
after 1.5 hours.
yes, it was filed on that same day, 24 December, but it was not listed because the file was not traceable, your lordship. Subsequently, application was given, other matters were listed, and this honorable court was pleased to issue notice. But so far as this matter, my lord, in respect of assessment year 10/11, it was not been listed. Filing date is 2023, my lord. All the matters were filed together. Fine. ये रह गया.
No, but you have taken, you see, more than almost a year to correct the
My lord,
defects.
we have given time and again application to the registry, my lord. Despite that, my lord, it was not listed. I also personally approached the registry why it is not been listed. Then it was told that file is not traceable. Thereafter, subsequently, again we have given more than, my lord, 5 times we have given application for listing. Except this matter, my lord, all matters were listed except this. All the matters were filed together.
What is the interpretation in that Patel?
Patel brothers,
Brothers?
what has happened, my lord? In that Patel brothers, this honorable court held that section 5 of the Limitation Act will not be applicable in respect of the revision filed before this honorable court, my lord.
Yes.
Because the VAT Act is a special act and there is no provision for condonation of delay.
Yes.
That section will not be applicable,
Yes.
my lord. But in the present case, it was filed well within time. That's why this honorable court has waived that objection raised by registry. Because the registry has not, my lord, detected the period which was at the time of filing between filing and, my lord, ready for delivery, your lordship. That was observed by this honorable court and it was waived, my lord. Order date is 6/1/2025.
Yes.
Because in the other cases, we have filed the affidavit.
Same issue, my lord.
But Mr. A. Goel, learned counsel for the petitioner, as well as Mr. B. Gogoi, learned standing counsel for the
Taxation.
state GST. Appearing for all the respondents. The order dated 30/5/2024 passed by the Joint Commissioner of Taxation from Assam, in respect of the assessment years 2005-6 to 06 Tier 2, 2010-11 sale by way of this revision filed under section 61 of the Assam Value Added Tax Act, 2003. Next, for the learned counsel for the petitioner has submitted that this revision petition was filed on 12/8/2024, and therefore within time. It is 3 months' time,
3 months, 90 days.
within time. And on an erroneous assumption that Limitation Act would be applicable, the file was not cleared for listing, and that the defect of non-payment of port fee was cured on 19/3/2025, and therefore is just wait for some time.
My
we'll have it, has to be clear. Look at the office note. How they've,
Calculated one.
how they have calculated, how they have cured the defects. These are not very clear.
In fact, same objection was raised by registry in respect of other matter, my lord. That was because the time, my lord, spent.
Now look at this. First defect is cured in March. After that, in the next page, you find a defect clear in November. So what defect was cured in the first on March? That is written.
Written, my lord, it is not maintainable.
Court fee. First is court fee. Second defect, nothing said. What defect was cured?
They are saying both maintainable as well court fee.
In fact, the note 31025 says defects removed only on 31025. In the middle.
Hmm?
It says defects removed only on 31025.
So therefore, what defect was cured? There is only one defect notified. Can you tell us? No.
Yes, well, it will be here, there are two grounds are there. Two defects.
One is, my lord, in
It has been-
2025, both the grounds have been taken, my lord, regarding one is limitation as per Patel Brothers, other is your court fee, my lord.
Court fee, one is court fee, another is delay.
Delay.
But court fee 3 to 24 to 25. In the pre-page,
It is 29/3/25.
29.3.
Yes. And in fact, the objections were of my lord 27/3/25. And defects cleared in my lord 310/25.
This has to be taken up administratively. So don't say that it is secured and thereafter listed before the next paragraph. Issue notice returnable on how much time? Mr. Gogoi?
Already they have filed, my lord.
Returnable on 17/12/2025. Extra requisite extra copies be served on the next time for the and Council for Taxation Department within 2 days. Next paragraph, list the matter along with
1 of 2024,
revision petition
1 of 2024.
1 of 2024.
Deeply alright.
Item 2 for admission. Met Appeal 75/25. 03/25.
Appeal, my lord, were convicted on 376 AB, my lord. Sentenced to 20 years of.
Which is the judgment?
And
2024.
Which page is the judgment?
2024.
confirmed to me.
No, which page?
Judgment, my lord, you will also find at
It
page.
starts from 67 onwards.
67.
Within 3, no? 103 left.
But Mr. P. Kotogil and counsel for the appellant. Hence.
Will come in. It will explain. Come in. Yeah, it will explain. Oh, I got it.
I type on it. I type on it. Okay. Copy to my phone.
Notice will go to respond number 2, my lord.
Also matter.
Passed by the learned Special Judge Poxo Morigao in connection with Poxo case number 88 of 2019, thereby convicting and sentencing the appellant to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 20,000 with default stipulation under section 376 AB IPC. And in view of the said sentence, no separate sentence was awarded under section 6 of the POXO Act. It is admitted for hearing, call for the relevant records. The appellant shall take steps within 2 days for service of notice on respondent number 2. Next para, the registry shall process the notice and hand it over to the office of the public prosecutor ASAP for onward service on the respondent number 2 through the jurisdictional police station. Next para, the officer in charge of Lahorigarh TS shall ensure that the service report is returned prior to the next date fixed for appearance. Like the date of appearance is fixed on 7 January 2025. The same notice on interlocutory application. Notice on interlocutory application also, same returnable date.
Item 6 for orders, criminal appeal 380/23.
May I please the lordship? My lord, today we are going to move the bail application, that is 989, against which the learned PP has also filed objection that we have received. My lord, I am in custody since last 1175 days, judicial custody. And the punishment is for life. So 1175 days, I'm in jail. But now, to consider my bail application, I made lots of kind attention. Kindly see yes 4 and 12.
Paper book.
Yes, paper.
Page 4 of the paper book.
In paper book, yes. In the court of SDJM Bijni.
Then we go to
So, my lord, case was filed before the learned court.
we go to the action.
Complainant Sri Purno Arjo, that is, he is the father of the victim
Mutual.
guard. And accused Uttam Mandal, for whom I am moving this bail application. Kindly see date of incident 15/12/12 and 18/5/13. And case has been filed on 18/6/13. So 18/6/13, almost from the first day.
Well, just one thing, Lord, your lordship. Now, so far, these petitioners are concerned, so the bail is concerned, my lord. These are the persons who has been convicted by adding 149, my lord. Now, I just point out only one thing, your lordship will kindly see, my lord, will definitely give a chance to, if they want to file an objection to that, my bail application. Lordship, the last page of the judgment, last two fields, 80, page 80, my lord. So for my, page 80 of my. So the Larnet trial court has dealt it separately. 302 has been separately dealt. 447 has been separately dealt. Now 149 also, we have not been acquitted from the charge of 149, my lord. Admittedly, my lord. So there cannot be, we are not in trespass, my lord. Kindly see paragraph 64, my lord. Just paragraph 64, my lord, your lordship will kindly see. Now, so may I read, my lord, 164, 64, para 64, my lord, the conclusion of the, after the conclusion of the judgment. In the light of what it has been discussed and pointed out above, I have no hesitation in my mind in holding that the prosecution has succeeded in proving the case against accused Debor Burman, Rajiv Das, Tapesh Das, Ojit Burman, Niren Burman, and Dhananjay Kaur, who are the petitioners. Three of them are petitioners before lordship. They are hence found guilty of committing offences punishable under section 147, 148, 449, 302, 149, my lord. Now, lordship can say 149, my lord. Then IPC and accused Ojit Burman is also found guilty of committing offence punishable under section 325 IPC, and they are convicted accordingly. Accused Debor Burman, Rajiv Das, Tapesh Das, these are the petitioners before us. Ojit Burman, Niren Burman, and Dhananjay Kaur are acquitted of charge under section 427, 149. Now, what 427 is illegal trespass, my lord. So we are acquitted from the illegal trespass, 427, 149, common intention, my lord. Lordship, now, unless and until there are a specific allegations, so far we are concerned that we have given a blow, down blow, mid the blow to the Nandi Singh below. So number one, the Larnet trial court has held that so far trespass is concerned, we are acquitted. No, any other 149 is concerned, my lord. .427 is, my lord, my lord, illegal trespass. If IPC, my lord, question is what? 427.
Mischief causing damage.
Oh, mischief causing damage. Mischief causing damage.
The amount of 420.
427. Causing damage is what, my lord? 141. That means they are participating because what it says, they have entered the house by cutting the doors on the thing. 447, huh?
427.
Hmm. Roma Borman, my lord, they also succeed, Roma Borman and my lord Ankur Borman, my lord, they have been acquitted. But what your lordship has stated, that there are about 13, 14 people, they cannot be named about except 4 or 5. The Roma has been specifically stated by my lord, in 164 statement also, what has been exhibited at exhibit 1 and 2, my lord. There are as many as 164, 164 statement. My lord. Only 2 of them has been exhibited, 1 and 2. PW3, my lords, and Minu Kolita Bormon, while recording her statement under section 164 and exhibited at exhibit 1 has said, all the person has entered there. My lord. But whereas, including the Roma, my lord, who has been acquitted. And Roma caught hold of the hairs of the wife of the deceased, the non-deceased wife, my lord, and obstruct him not in entering in this city. Now, exhibit 2 is also by the PW4, my lord. He has stated a different thing, my lord. Nobody seen, my lord, who has inflicted the injury, my lord. There are as many as 12%, my lord, except one has said it is the Devo. He has gone inside there and had inflicted injury on the head and other injuries, several injuries. The rest of are outside the place of occurrence, my lord, in the house of Nandi Singh.
I won't remember the people by name, but what I find is that as per the evidence, few of the accused persons, including these 3,
My lord,
they came into the house wanting to assault this man, and this man went and
went inside. my lord.
had in a duli. What is a duli? I don't know.
Duli means, my lord, if I am not wrong,
Duli is a,
that used to keep
is a containers, my lord,
rice, my lord.
who used to keep the, not rice, paddies.
Paddies, my lord.
Okay.
Rice is the, for the,
After billing.
He was hiding there, and thereafter, out of these people, one said that they were armed with lathi.
yes, my lord,
Then
And-
striking is by
Debo,
Devo,
Debo, my lord.
by Dao.
Dao, my lord.
But your presence in the home is seen by another accused
Yes, my lord, that,
inside the home.
my lord, what I want to say, my lord, well, so far now I'm going in the bail matters, my lord, not in the final matters of
No, I
an appeal is
understand.
concerned, my lord.
You understand?
But I know, my lord, very limited purpose, my, is very limited, my lord. Now, if you kindly see, the Roma, my lord, has been acquitted. Roma is acquitted. And Roma's name has been specifically, my lord, has been cited by all the witnesses that Roma has gone there, what have they now obstructed her wife, that this is the complainant, and also beaten. And against him, 325, because of 325 has been added because of what? That there is an injury over the head of the complainant. So she's not been acquitted from the 325, also acquitted from 302 also, adding 149 million, because she is also a member of the unlawful assembly. So the prosecution story is concerned, my lord. So we have been left out. Roma has been dealt, the trial court has been dealt with the Roma in a different way, my lord. So that's why I have left your lordship. So the bail is concerned, my lord. Or if you want, lordship want to hear the matter entirely, so your lordship, I leave it to your lordship, my lord.
My lord, it can be disposed of, my lord, not today, but my lord, I have not prepared this thing because we have not filed the objection in the IA. So if entire matter is, your lordship is going to heard in another day. Bail, my lord. And my lord, I need some time to file objection, my lord. Short date, any date, my lord. My lord, next week. My lord. My lord, sorry, my lord, not 27. I will be out of station, my lord, on on 30th, my lord. Yeah. 30th Sunday. Correct. 1st of December, my lord. 1st of December.
কিবার পড়লে?
Monday বলবো।
কে ভট্টাচার্য?
Blessing. Blessing.
Item 10.
Item 10, lordship, LCR received. And notice was also served, but I didn't find the return report, lordship. Service return report. Upon informal, lordship. My lord, I don't have the report right now, but I can take inspection, my lord. My lord. Today, my lord. My lord. My lord.
Item 11.
May I please your lordship? Lordship, this is a legal aid matter. I am for the petitioner, my lord. The petitioner is serving presently his sentence in Dhemazi District Jail, my lord. And yes, my lord. And there has been a delay of 175 days.
Offense under POCSO Act,
Yes, lordship.
Mrs. S. Medhi, learned legal aid counsel, as well as Mrs. S. H. Boran and APP for the state. Next, issue notice on this interlocutory application under section 5 of the Limitation Act, by which the applicant is seeking condonation of delay of 175 days beyond the period of limitation in filing the connected appeal. Issue notice returnable on 5th of January 2025. Legal aid counsel shall take step for service of notice on respond number 2 by registered post Bidedi. And in addition, further steps is required to be taken for service of notice on respond number 2 to the jurisdictional Jonai Police Station. It takes steps within 2 days. Steps within 2 days for service of notice on so and so. Then the registry upon after processing the notice shall hand over the notice to the learned APP for onward service of notice on respondent through to the jurisdictional police station. Next, the officer in charge of Jonai Police Station shall ensure that the service report is returned to the court. It's 2 days prior to the next date of the state. Next, list on 5/1/2025.
I'm highly obliging. In the meantime, PCR may be called for.
Pardon me.
In the meantime, PCR may be called.
LCR will not come because appeal is not been admitted.
Lordship, since DIA is there.
It's only IA for
Yes.
condonation of delay.
Yes. What any bad luck? 175.
Item 12.
After the incident is 7/12.
Lordship.
No, not 7/12.
It is 6/4/21, my lord.
Date of incident
6/4/21, page 22 of the IA.
6/4/21.
Yes, lordship. And date of FIR 7/4/20.
Date of FIR 7/4/20.
21.
FIR was lodged on 7/4/21.
Yes, lordship.
7/4/21.
Lordship will find the FIR page 4 of the paper.
Doesn't it look strange to you?
Lordship,
The entire presentation of case
Lordship,
doesn't it look strange to you? Something somewhere missing?
Lordship, so far the FIR, contents of FIR is concerned, it might happen, Lordship,
No,
Let
the
us-
mother is not a witness,
Lordship,
correct?
Lordship.
Now, the incident on 6/4/7/4 is the FIR.
Lordship,
This police personnel takes her to medical examination on 17/12,
Lordship,
8 months. What is the
after,
explanation of delay?
Lordship. Lordship, actually, Malanit is today moving the IA for suspension of sentence, Lordship. So to that regard, I have to go through the file and will file objection.
You said you have filed objection.
No, Lordship, we have not filed our,
You have not filed.
Yes.
Okay, it's not that you have filed it. That's why
No.
we are examining the record.
yes, we have not.
How much time?
3 weeks time may be given,
Give us a date.
Lordship. Can it be on, January 6th? Oh, this is very good, December last month. January 2nd, 4th would be. Fourth, not be. Huh? Okay. January. Lordship, can it be on 9th of January, 2026?
Very good. Mr. D. Bhattacharya, and counsel, legal aid counsel for the applicant. And Mr. S. H. Boran and APP for the state. None appears on call for respondent but two. Issue notice on this interrogatory application for suspension of sentence. Okay, filed under section 430 of the PLFS. But the notice is made returnable on 9/12/2025. Objection from my is by state and the respondent can be filed by them. List on 7, sorry, 9,
9/1,
12, 9/1,
9/1, 2026.
9/1/2026 for consideration of the period for suspension of sentence.
Highly organized. Lord.
Item 13 for hearing.
PJ Talukdar, senior counsel. Am I is good? Item 14. Mr. Dutta.
the statistics of the doctor. When he is arrived.
doing some other duty, and again, I tried to contact another police officer, my lord. And they said, my lord, they have maybe there is miscommunication, they have not received from, but our office, it was sent on 13th of June, my lord. Then, be that as it may, I have personally, my lord, today itself, my lord, I have WhatsApp her, my lord. And by tomorrow, day after tomorrow, it will be served. my lord.
You,
Malo, now,
you want us to issue a fresh process?
No, no need, my lord. I have directly WhatsApp the petition, this copy, my lord. So they will serve, my lord, along with the court order.
Okay,
They will
yes.
take a receipt, my lord.
now that is all right. I'm not on that. Let him get it by next week or in day. Or in the meantime, the paperwork is necessary. So we'll process, your lordship direct for processing the paperwork. Record,
Oh,
record has come, my
record
lord.
has come. Okay, we'll direct the paperwork to.
My lord.
Yes, yes.
Okay.
Directed, to direct the paperwork to PPL.
Heard.
Thank you.
Mr. R.P. Sharma, Learned Senior Counsel, assisted by Mr. D. Dole, Learned Counsel for the appellant. Mr. R.R. Kaushik, Learned Additional PP, has submitted that his office had sent the process in respect of respondent number 2 to the
Okay.
Sutia Police Station for onward service to the respondent number 2. Stop. He prays for and is granted 3 days time to obtain instructions regarding service. Next para. In the event the process has not been served, the officer in charge of Sutia Police Station shall do the needful for service of process on the respondent number 2 and return the service report at the earliest for being placed before this court by the Learned APP. Next para. In the meanwhile, as the records of the trial court is received, the registry shall prepare a paperwork next para. Okay, then please you give some time for paperwork.
Yes.
The service report is also made returnable on the same day.
Particular that same day.
List on 7/1/2025 for service report on respondent number 2 as well as for awaiting preparation of paperwork.
Preparation of paperwork, we are also.
Same day for appearance as well as for preparation of paperwork.
And one paper book?
Yes.
Obliged.
Item 14. One.
My lord, here, although I have received a copy, my lord, filed by my learned friend, probably that is not on record. And my lord, one more thing, I have lately I have received this, my lord, although I have gone through very small affidavit. Here, my lord, my learned friend is emphasizing on one thing, that arrest memo will complement the section 50 CRPC. I, my lord, respectfully do not agree to that, my lord, because of a recent, my lord, otherwise also, but this is 2025, my lord, an authority of the Supreme Court, my lord. It says a arrest memo, my lord, could not, my lord, take place of section 50. Section 50 is independent, it is mandatory and independent. So, my lord, I will also bring it on record, if your lordship permits. So, again, this on only one page judgment, but still I want to bring it on record, my lord. Yes, then my lord, if my lord takes cognizance of that, my lord, I can give. I can give, my lord. Yes, my lord. May I read this, my lord? Ekon apunak disu. Yes, sir.
Not. My affidavit also come, in the meantime, come in the record. My affidavit filed by me.
My lord, this is 2025 judgment, my lord. Ashish Kakkar versus Union Territory of Chandigarh, my lord. May I read just one quote? Yes, my lord. It says the appellant was arrested in connection with the this and this registered under this and this section of the IPC and remanded to police custody for a period of 3 days. By the present appeal, the appellant has challenged both his arrest and the remand order dated this on 3 grounds, namely, there is a clear non-compliance of the mandate under section 41A of the Code of Criminal Procedure. The appellant was not heard at the time of remand, and the ground of arrest as mandated under section 50 of the Code has not been furnished to the appellant against the mayor arrest memo. We are incited to consider only the last issue raised by the appellant with respect to the non-furnishing of the ground of arrest. Upon perusing Annexure P3, we can see that what has been provided in the appellant is only an arrest memo in the prescribed format, which is meant to be given to the appellant by way of an intimation. It has been filed with the name of the appellant along with the place of arrest. Additionally, it has been written that he has been arrested based upon a statement of the co-accused. We are in agreement with the submission made by the learned senior counsel appearing for the appellant that the said arrest memo cannot be construed as a ground of arrest, as no other worthwhile particulars have been furnished to him. This brings a clear non-compliance of the mandate upon section 50 of the code, which has been introduced to give effect to Article 22(1) of the Constitution of India 1950. We are inclined to set aside the impugned judgment, particularly in light of the judgment rendered by the court reported at Purkayastha versus State and City of Delhi. In such view, the matter, the impugned judgment state set aside and the arrest of the appellant followed by the consequential remand order are also set aside. My lord, my humble submission is this: Section 50 is independent of arrest memo. Arrest memo may, that intimation and the arrest memo may have certain particulars, but Section 50, the mandate, my lord, it has to be complied with. In our case, my lord, it is not so, and that has been held by this honorable court also. In a absolutely same Section 50. Yes, yes, my lord.
No,
Otherwise, my lord, my part is already done.
yesterday, Saturday, Lord, sir. It is available in the section, Lord, sir. They said unless much of. Lots. Not
Yes, my lord, I have annexed all the orders otherwise, yes. Yes, my lord.